Maybe you can serve them, not to give us a copy.
You know, our instructions are, we have been served this application now. Filing processes takes time. We will raise issues of law within this application because the PO is about law, either during submissions or outside. Because we don't have it now, we are seeking that we do not deal with the PO as an item per se. Number two, the state has asked for which paragraph that we intend to cross-examine. We shall be cross-examining the deponent from paragraph 5 to paragraph 28. The paragraph that we cross-examine.
Yes.
So let's proceed on the premise of your application.
That's fine. Yes.
Once they will raise it, we deal with it as they raise it.
That's right. You know, only that to add that the proper name of a PO is a notice of preliminary objection. So that we need notice. If they intend to bring a notice in within, let them not throw it within the application because we shall not have notice, or rather sufficient notice to deal with it. But as be that as it may, let me proceed with our application. As is already indicated, our application is dated 16th of June 2025, the year of the Lord. The substantive prayer sought is prayer B on the face of the application. That prayer is that the respondent before court be remanded at the Langata police station or any other police station within the Republic of Kenya and the reason being, and this is a justification, that it will enable the applicant herein through the Independent Policing Oversight Authority to continue and conclude investigations in respect of the facts, the basis of the arrest of the respondent. Your application is based on both law and facts. And to be more specific, Articles 24, 29, 49, of the Constitution and Section 36, capital A, of the Criminal Procedure Code. We will also make references to the decision of the High Court of Kenya at Uhuru, Honorable Justice Joy Ngugi, a judge I hold so highly, in the decision of Sudi Oscar Kichumba versus Republic, and this is criminal revision number 208 of 2020. Fundamentally, that decision of the learned Justice Ngugi, as he then was, because he now sits at the Court of Appeal, cites and makes reference to the decision of the High Court of Kenya at Milimani delivered 4 years before it by the learned Justice Luka Kimaru, as he then was as well, because he equally sits at the Court of Appeal, in Michael Rotich versus Republic. And we preempt that the defense are likely to run away with Michael Rotich, so we are going to hit hard on it before they get a chance. In summary, what we are requesting this court to do is to issue an order for what the Constitution calls detention continuing. So that the respondent remains in custody, that's the common name that we call it custodial orders, for purposes of completion of investigations. Cognizant of the limited jurisdiction of this court under Section 8, subsection 2 of the Magistrates Court Act 2015, our references to Article 29 is only in passing and for purposes of laying basis that every person, I am paraphrasing, every person has the right to freedom and security of their person, including the respondent. In further laying of the basis, that Article 24 of the Constitution allows for limitation of rights under the Constitution, save for the rights under Article 25 thereof. So that while we acknowledge that the respondent has a right to freedom, right to security of his person, and a right to liberty, all those rights fall outside Article 25 and can be reasonably limited. Where there is justification. And where, Your Honor, it is established that the kind of limitation we are seeking in the nature of detention continuing is the least restrictive measure. So that, Your Honor, once we have established, as we have, that Article 24 permits the limitation of the right to freedom and liberty, then we shall, through my learned senior, take the court through our affidavit to establish the justification. But, Your Honor, Article 49(1)(f)(1) sorry, that is 49(1)(g), Your Honor, I'm sorry. And if you allow me to read, an arrested person has the right at the first court appearance to be charged or, and this is important, as informed of the reason for the detention continuing or to be released. And so out of the three available options under Article 49(1)(g), we have come to court to seek detention continuing. Your Honor, with that legal basis, allow me to make a reference to the learned Joy Ngugi J, as he then was, in Sudi Oscar Kipchumba.
The right of making submissions. We have made our submissions. So that Once they have done this, they will surrender the list for cross-examination, and they'll have no right. Procedurally, it is the deponent to be put on the dock, and the deponent is cross-examined. The respondent lawyers submit. It's the reverse. And that's why I'm asking, is my old JV abdicating the role?
My answer was just laying the basis so that once the deponent comes to the door, then we can proceed from there. So let maybe just finish with your basis. I believe it's more or less an opening statement.
He has done an opening statement.
Yes,
We
let him
will
finish.
then be doing an opening statement to lay the basis and counter what has been said, because he is doing actually an opening statement. We will also be seeking that we also put an opening statement and before the court.
So
That's all.
Sorry, I do not understand the basis of that argument, because we are arguing